Hello friends, welcome to my channel. Today I'm going to discuss about the Union Territory of Chandigarh Victim Assistance Scheme 2018. This scheme was commenced on 31st of July 2019. The Administrator of Union Territory of the Chandigarh made the Victim Assistance Scheme 2018 in exercise of the powers conferred by Section 357A of the Code of Criminal Procedure and in compliance to the directions given by Honorable Supreme Court of India, Wide Order dated 11th May 2018 in writ petition number 565 of 2012, titled as Nipun Saxena vs. Union of India and others, in view of the key guidelines laid down by Honorable Supreme Court of India in writ petition titled as Tehseen S. Poonawala versus Union of India. The purpose of the scheme is to provide funds, assistance to the victim or his dependents who have suffered loss or injury or both as a result of the crime and who require rehabilitation. I would like to discuss some important definitions under the scheme. First of all, I would like to tell you who is a victim. A victim means, as defined in Clause WA of Section 2 of the Code of Criminal Procedure, a person who has suffered any loss or injury caused by reasons of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir. The victims of sexual assault who has suffered mental or physical injury. Other person include which is a result of offence mentioned in the attached schedule, including Section 304B, Section 498A, in case of physical injury of the nature specified in the schedule, including the attempts and abetment. Any offence committed against the victim under POCSO Act, the acid attack victims under Section 326AI 5PC, the victims of mob violence and mob lynching. Then I would like to discuss that who is a dependent. Dependent is any wife, husband, father, mother, grandparents, unmarried daughter or minor children of the victim as determined by the State Legal Services Authority or District Legal Services Authority on the basis of the report of the subdivision magistrate of the concerned area, SHO, IO, or on the basis of material placed on record by the dependent or its own inquiry by way of affidavit. The competent authority is an authority which has been delegated the powers to withdraw compensation amount from the Victim Compensation Fund and to release to the Member Secretary State Legal Services Authority UT Chandigarh. State or District Legal Service Authority UT Chandigarh is defined under the Legal Services Authorities Act 1987. Injury includes any bodily injury or psychological injury or loss of earnings, including loss of opportunity of employment and education and expenses incurred on account of legal and medical expenses. The Victim Compensation Fund is a fund segregated for disbursement to the victim as defined under this scheme out of the Union Territory of Chandigarh Victim Compensation Fund. Then we also need to know what are the sources of Victim Compensation Fund. One is grant received from Government of India. Second is the amount of fine imposed under Section 375 of CRPC. The cost of the assistance shall be recovered from the wrongdoer accused and shall be treated as public demand to be recovered in abundance with the relevant provisions of law. Any amount of cost ordered by civil or criminal tribunal to be deposited in this fund, which includes donations, contributions received from international, national philanthropists, charitable institutions, organizations, and individuals permitted by the state or central government. Contributions from company under the CSR also come under this scheme. Then we talk about the eligibility for assistance or compensation. Eligibility for grant of assistance shall be decided after following the criteria as prescribed under the scheme. However, the compensation received by the victim in any other scheme with regard to Section 357B CRPC shall be taken into account while deciding the quantum of compensation. What is the procedure for grant of assistance for interim final compensation? Mandatory reporting of FIRs immediately after its registration to SLSA or DLSA Chandigarh by SHO, SP, DGP by sharing soft hard copy of FIR qua commission of offence so that SLSA, DLSA can initiate preliminary verification of the facts for the purpose of grant of interim compensation in deserving cases. The application is prescribed pro forma, supported by an affidavit along with a copy of first information report or criminal complaint, and if available, medical report, death certificate, copy of judgment, recommendation of the court can be filed by the victim and his or her dependents before the concerned SLSA, DLSA for grant of interim final compensation. In case of acid attack victim, the deciding authority shall be Criminal Injury Compensation Board, as directed by the Honorable Supreme Court of India in the famous case of Lakshmi versus Union of India. Well friends, this is the end of my first video. In the second video, we will discuss more about the victim compensation scheme as applicable to Chandigarh. Thank you. Please like, subscribe and share my channel. Thank you.